Let me bring on Alexandra Kazarian, a criminal defense attorney and friend of the show. Thank you so much for coming on. Okay, got to ask you this. I want to start with Diddy's basically giving up his attempts to be released on bail. He had a pending appeal with the Second Circuit Court of Appeals, basically withdrew that. Why give it up? Why not just try? What does he have to lose?
Well, there's a number of different reasons, but one may be because you feel that who you're appealing to isn't friendly and you don't want to create bad precedent. So you don't want to have a higher court make a ruling that's bad for you. So they may have been reading the tea leaves, known who they were going to be arguing in front of, and thought, you know what, I don't think this is the right time or the right court to do this in front of, because God forbid we get a ruling that's even worse than the one that we had in the lower courts.
And I also think maybe he doesn't want to spend the resources and the time fighting bail, which looks like he's not going to get, and focus on the trial that's coming up in May. I want to talk about what happened today. So Diddy's defense team says that they want prosecutors to clarify the scope of his crimes. They even asked for a bill of particulars. What part about this is so vague, and do they have a good argument? Do they have an argument that he has a right to know exactly what this case is about?
Yeah, absolutely. In conspiracy charges and RICO charges, things like that, you're charged with committing a crime with somebody else, and the underlying crime does not have to be defined when it's being charged. And the prosecution, the people, the government, whatever you want to call them, they are allowed to wait until you're in front of the jury to tell you what their theory of prosecution is, what exactly their prosecution theory is. They have to give all the evidence. They have to hand over all the discovery. But sometimes in cases like this, where the statute itself is not defined, you have to comb through the evidence and sometimes guess, are they talking about working connection with this witness over here, or is this witness over here? So yes, that it is sometimes in these kinds of cases really hard to find out exactly what theory the prosecution is using. And sometimes they don't even make a decision until game time. So it's forcing the prosecution to abide by a certain theory so that they're not changing it as they go.
And I wonder if they have to make it particularized, if that'll actually delay the proceedings so he has enough time to prepare for that. I did want to ask you about discovery, though. You mentioned discovery. So prosecutors say they're going to turn over all the discovery to the defense by the end of the year. This trial starts May 5th. Again, goes into the other question. Is this really going to happen in May? Is this enough time for the defense to prepare their case, to prepare a defense?
I mean, you may be very correct in that abandoning the bail appeal is a way to proactively start getting ready for this mountain of discovery that's coming. So yeah, it maybe was a game time decision that we're not going to waste our resources here because we're going to have to bear down if we want to have this trial in May. There's pros and cons always of executing your right to a speedy trial. Sometimes you want to get to that finish line quickly, but sometimes it does help to age a case. So I think once the defense looks at all the discovery, they'll have to make that decision as well. Do we want a continuance or do we want to rush to that finish line?
And by the way, talking about clarity, I thought that this was very notable. I don't think it's being talked about enough. The prosecution today, they didn't provide much clarity on when or if they will file a superseding indictment in this case. But they said, we're aware of the trial date, and they said any additional charges will have little discovery. So again, when I meant a superseding indictment, I mean additional charges against Sean Combs or amended charges. They're aware of the trial date. They said they're, whatever additional charges could be, would have little discovery. What does that mean?
Well, it may mean that they've got something in their back pocket that they're deciding whether they want to add as a superseding charge. They're trying to decide whether adding the particular charge that they're thinking of is going to delay the case, if it's going to complicate their case. So it sounds like they already have an idea of what they may charge, and they have to. There's no way that they could say that they know what the discovery is without knowing what the charge is going to be. But it's not necessarily, everyone's thinking there's all these accusers in civil court that are coming out, and are those going to be added to the criminal case? It's not the same, because prosecutors have a duty to file only cases that they can prove beyond a reasonable doubt. They have to be able to convince a jury. And in civil, it does not work like that. Civil cases can be won by 51%, not proof beyond a reasonable doubt.
And there are certain statutes they're suing under that allow them to bring back much older claims. Real quick, we have a minute left. He was reportedly thinner. He was reportedly grayer, but also in good spirits. Is that surprising to you?
I think that he's a very thoughtful person. You've seen throughout his career that positivity is a big part of what he preaches and how he lives his life. So it doesn't surprise me that he is outwardly projecting positivity.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.